Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Nashville on May 3rd through the 4th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and today's guest is Michael Goldberg, a senior partner at Baker Botts, who offices in both the New York and Houston offices of the firm. Michael is the co-head of the firm's International Disputes Group and has represented numerous companies in regard to government investigations. Specifically, over the last several years, he has represented Cobalt International Energy in connection with several FCPA investigations initiated by the SEC and DOJ. Thanks for joining FCPA Flash today.
That's my pleasure. It's a pleasure to be with you.
Now, since 2011, your client Cobalt was under FCPA scrutiny not once, not twice, but 3 times, and in all 3 cases refused to settle. Can you provide listeners a brief overview of your client's FCPA scrutiny?
Sure. Cobalt was a relatively new and small company comprised of some of the top oil and gas specialists from various other companies. They focused on deep water discoveries in the Gulf of Mexico and offshore Angola. With regard to Angola, they negotiated with the national oil company, Sonangol, and obtained 3 offshore blocks for development. But after obtaining the blocks and paying for them, rumors started coming about that certain government officials had secretly owned other partners that had been added by Sonangol into the block. As with most concessions, oil-producing countries want to have domestic companies involved in their production. Thus, Angola added a couple of locally owned companies. As it turned out, the rumors developed that in one of those companies there was government ownership, and in fact, that turned out to be true. The first 2 investigations arose out of those facts.
And how did these government investigations begin?
Well, the ironic part of the investigations, they began with self-disclosures by Cobalt. Cobalt reported in its 10-K that there were rumors of government ownership. And as a result of that, the Los Angeles office of the SEC saw that and opened an investigation. Cobalt then contacted DOJ and informed them of the SEC investigation. Those 2 cases were then declined by respective agencies in, I believe, 2015 and 2016. The Washington office of the SEC opened a new investigation in 2017, last year. This investigation, while it still dealt with our Angola operations, dealt with a social payment the companies were required to make for the development of a tech center in Angola. Since the tech center was never built, the SEC was looking into whether there was some type of violation of the FCPA. That investigation was just closed after 11 months.
So let's go back to that first instance of scrutiny in 2014. Your client, and this was publicly disclosed, received an SEC's Wells notice. This is not normal in the FCPA context necessarily, so can you describe the dynamics of the Wells notice and how your client responded to it.
Sure. First of all, let me just say, with regard to the first two investigations, neither I nor my firm was involved at the initial stages of the investigations by DOJ and SEC. There were two other reputable law firms that were, representing the company in an appropriate fashion. We took over the investigations in around 2013 or so, before the Wells notice was issued. We then met with the SEC on several occasions, and we discussed not just the legal and factual merits of the case, but the difference is we also discussed with them, trial lawyer to trial lawyer, the reality of how a trial would take place in that case if it were not declined. And after open and transparent discussions with the SEC, they did the right thing and declined to continue the investigation. Since it's not an everyday occurrence for the SEC to decline a case against a company after a Wells notice, obviously the client and we were pleased.
Was the main negotiation point between you and the SEC and or DOJ a legal point, a factual point, or a little bit of both?
Well, it was a little bit of both, and also the trial aspect, as I discussed. I mean, clearly, we disagreed with the SEC on how they were looking at the law, and so we had real open and frank discussions about the law. With regard to the facts, obviously, with every investigation, that's the key as to what people knew, what people saw, and fortunately for us, we believe we had very good people and did the right thing, and so we went through the facts with them. But again, what I'd stress also is that you have, what sometimes lawyers forget to do is really look at the reality of life. If you're going to try this case, does the company have good witnesses? Do they have lawyers that know how to try jury cases? And so it's not just the law, it's not just the facts, but it's also the good and the bad points with regard to actually trying a case.
And indeed, in the FCPA's 40 years, the SEC has never been put to its ultimate burden of proof at trial in an FCPA enforcement action. That's a fact. That's a statistic, and pretty amazing to think about. Going back to perhaps some of the legal issues, are you able to say regarding what? Was it a corrupt intent issue? Was it an obtain or retain business issue? What was the precise legal issue that was being disputed?
Well, to just put it in basic terms for your listeners, the aspect of there being government ownerships in one of the partners obviously, drew attention and was a red flag. But the point of contention, one of the points of contention on the law is, we did not have any say or put those people or those partners into the transaction. That was done by the government state agency. And so it wasn't that there was, the position was there was no bribe, there was no thing of value given, there was nothing we did that in any way could be considered a violation under the FCPA.
Did the SEC nevertheless approach your company and saying, hey, do you want to settle this? You want to pay a settlement amount here?
Well, I would say that I would put it a little bit differently. We certainly had meetings in the first two investigations scheduled to see if these matters could be resolved. In fact, I specifically requested a meeting to discuss resolving the investigation. And at the meeting, we presented all of the facts and our case as to why this case should not proceed. The government then said, well, you called this meeting to get this resolved, so what's your offer of settlement? When I informed them, look, I don't have an offer, and I'm not going to make an offer. The room went silent for a minute. I explained to them, I said, look, by talking about resolution, I meant that resolution would be a government declination of any action. And while there were some awkward moments after that position, I think later the government came to respect our position, and indeed, whether they agreed or not on the law, they always acted respectfully and with regard to the case. And I'll tell you, perhaps the line that stood out the most was when I told him, the only bribe my company will ever pay is if we end up having to settle this case, because we felt strongly we did nothing wrong.
What was the reaction to that?
Well, it's funny, in human nature, you deal with different people. There was a look of surprise on some, and there was a chuckle by some, because obviously, that's a line that, it sounds worse than it really is.
Yeah, no, I hear you. So the SEC dropped that investigation in 2015. And were you surprised then that in March of 2017, the SEC was back at it and opened an investigation as to your client? And more broadly, do you think that second investigation, or perhaps it's third if we're counting these up, would have taken place if the company did settle monetarily the previous instance of FCPA scrutiny?
Well, no. Let me start off saying there's absolutely no regrets that we took such a strong position regarding settlement. It was the appropriate position to take, and indeed, those first two cases were declined. I don't believe for a second that settling or not settling the first two in any way impacted the second SEC investigation. You've got to remember, although the previous SEC investigation was by the SEC, it was by a different office, the LA office, and there were different agents involved. And so while the issues were all Angola or FCPA related, the Washington office in the second one, they absolutely felt this was a separate investigation.
Now, even though Cobalt, prevailed all three times when faced with scrutiny, I'm guessing there were several negative impacts for the company just going through this process. Could you describe some of those negative impacts?
Well, I suppose, first you've got to realize that any time a company does business in a country that has red flags for the government, there's always the potential for an investigation. Everybody realizes that. However, here the company went out of their way to ensure there were no violations. But your question's a good one, because in a lot of ways, I think this system of investigations is a broken system which requires cost, time, and resources which can be put to better use by both companies and the government.
And can you explain that in a little bit more detail, why the current system of scrutiny, largely outsourced investigations to counsel, reporting back to the government, that whole process, why that is broken in your opinion?
Well, a lot of lawyers or companies like to put the blame on just one side, the government, but I believe there's plenty of blame to pass around. I believe it's not just on the government, but you've got blame on the companies for this, and you've got blame on the outside counsel that companies hire. All three share in the system being broken.
And how so? Not so much perhaps in the unique circumstances of your client's scrutiny, but just more broadly speaking, how would you attribute blame in some of those instances? And are you referring to the length of time FCPA scrutiny lasts? Are you referring to the very much eye-popping pre-enforcement action, investigative fees, and professional expenses? What specifically are you referring to?
Well, I'll give you a general answer. Yes, all of those. But let's divide it up. Let's look at the companies, the lawyers, and the government. With regard to the companies, all too often the board or management simply wants to get the matter resolved, and they indeed will settle to eliminate risk, even if they believe they're completely right. The risks of continuing an investigation with millions of dollars in legal fees and internal fees, even if you know you're going to win, is sometimes too much for boards or managements to take, and that's appropriate.
And let's just pause at that one, because I agree with you. And on a micro level, that's a rational business judgment for one with fiduciary duties to a company and its shareholders to make. But the problem I see with that is when you aggregate Company A's rational business decision with Company B's rational business decision, with Company C's rational business decision, and so on and so forth, you get an area of law that is expanding, not because of the law, not because of the facts, not because of a legal decision, but just excessive risk aversion aggregated across many companies.
Look, that's absolutely right, and I would look at it from two perspectives. You know, clearly, if Company A, B, C, and D stood by their guns and didn't settle when in those situations when they know they're right and they did nothing wrong, then yes, this system, you know, could help get resolved. But we have to be fair to the companies. Companies have responsibilities and the board and management needs to look at it on that micro level, not the macro level. But even with regard to the micro level, I'll give you an example that companies can sometimes think about. When I was a young lawyer, I was national counsel for Ford Motor Company. I tried a lot of their product cases around the country. And at that time, Ford was basically settling all the cases, you know, as a cost measure. Well, a new GC came in, and we had discussions and decided we weren't going to do that anymore. We were going to try cases when we felt absolutely we were right. What was the result of that? The first year, expenses went up because of all these trials. But every year since then, Ford saved hundreds of millions of dollars in legal fees because plaintiffs' lawyers stopped bringing those cases because they knew that the company was not just going to give in. Now, that example is not a perfect one for government investigations because the fact of the matter is the government's going to bring an action if they truly believe there's something wrong. They're not going to be scared off because a company's going to try the case. But if the companies, and again, it's now the macro level, A, B, C, and D, can somehow stick to principles when they're right, and I emphasize that, then I think that could have an impact. And that's where I put when I say some of the blame on the companies, though it's perfectly understandable.
So what about outside counsel now in terms of these the broken system that you're referring to in terms of internal investigation, settlement, etc.?
Well, at the risk of having some of my friends upset with me, I'd say there are a couple of issues with regard to outside counsel. One, you have more than a small minority of lawyers that simply don't mind if an investigation lasts a long time because the legal fees are what run their law firms.
Yeah, it's in their interest to do a where else investigation and fly associates and others all over the world kicking the tires and turning over the stones.
You know, for many lawyers, I say it's the greatest practice. You travel around the world, you interview people, you talk to the companies, and then you recommend settlement, and that's it. But let me, joking aside, I'll say I don't believe this attitude is held by most of the top white-collar defense lawyers. I think that the real problem, however, and for companies to think about, is that, you know, many of the white-collar lawyers have gotten into that rut of settling all the cases. And part of the reason is they, like companies, are risk-averse. And I always find it interesting. I always tell companies, if you're going to pick defense counsel, a lawyer to represent you with the government, find out how many cases these lawyers have actually tried to a jury. Because at the end of the day, part of the decision on the part of the government is if they try this case, are they going to win? The government doesn't want to lose cases. And part of that decision is, are the lawyers on the other side really trial lawyers, really jury trial lawyers? And most importantly, the lawyers you hire are the ones whose experience are going to inform their judgment about whether to recommend the case settles or not, or whether the case is winnable. And, are these lawyers the ones that have the guts to go try the cases, even if you know you're going to want to settle?
So what about any blame on behalf of the government here?
Well, sure. And let me start off. In my experience, I think there's only as with any large group of anybody, I think there's only a small minority that act inappropriately. I certainly have had a couple of occasions like that, but it did not happen. Back to Cobalt, it didn't happen in these investigations. The people we dealt with truly were doing their job and believing what they were looking into. So let's set aside the cases where the government or agents act, over the line. To me, the key problem is that sometimes our government and the lawyers and FBI and people that deal with this on behalf of the government forget the harm that is caused simply by having an investigation open. There is no timetable for DOJ or SEC to conclude an investigation. Now,
well,
look,
just there, technically there would be if a company would not waive or toll the statute of limitations, which is often what companies do to demonstrate cooperation.
You're right. Limitations is always there, and even in the Cobalt case, they asked us to extend, and we did. And it's again, part of this is having good faith with the government and showing you're being transparent. So you almost have to do that many times. But the issue is, if there's one change I would make within the government standpoint, is sort of convincing them that the adage, justice delayed is justice denied, really applies to investigation. They decide when to open investigation, when to make it public. But once they do, there needs to be a bit more urgency on their part, especially if you're going after individuals or smaller companies, recognizing the reputational harm and that these need to be concluded quicker. And so that, to me, is setting aside the outlier of bad actions or whatever. That, to me, would be the one thing I would try and push for is that attitude of we can't just sit here and let it sit for years.
Well, it's funny because even the DOJ, at least in its public statements, rhetorically recognizes that. I've been tracking some of these issues for a very long time, and approximately 10 years ago, high-ranking DOJ officials were publicly saying the days of year-long investigations are long over. More recently, the top-ranking DOJ official said something to the effect that our goal is for FCPA scrutiny to last months, not years. But yet the statistics are what the statistics are, and that is, generally speaking, FCPA scrutiny on average tends to last about 4 or 5 years, which is fairly ridiculous if you think of it from the standpoint that the DOJ, the SEC are dealing with cooperating companies, and both of those agencies have specific FCPA units.
Yeah, and I will tell you one thing, though, and time will tell, but what I've seen recently, when you look at now the heads of the FCPA at DOJ, Dan Kahn, or at SEC, Charles Kane, now that they're there, I can tell you they both understand this issue, and, I believe absolutely that with regard to these two individuals that are running FCPA and the two agencies, they do see the issue and they are trying to make this more efficient. And you can look at just this third investigation we had. From start to finish, it was 11 months. And they came in and they did, a tremendous amount. It cost a tremendous amount, but they did it. They understood that it needed to be quickly. So I am hopeful, and a lot of this all depends who are the leaders at the top. Today, I believe, maybe unlike in the past, we've got leaders at the top of both agencies that do see this issue.
Yeah, I mean, I'm no doubt that third investigation of your company, there were certain efficiencies and general information learned in the first two that probably made that third one faster. But a concluding question, what should be the big picture takeaway point here for board members, audit committee members, general counsels, as to your clients' numerous instances of FCPA scrutiny and refusing to settle?
Well, that's, I guess there are a lot of lessons, but it's hard to sort of encapsulate them all. I'd say, look, first of all, a company like Cobalt has to be proactive with compliance. You need to have counsel involved. You need to look at at the issues, have programs in place. But unfortunately, there are times when you can't control everything. And that's when you need to be ready. You need to be ready to talk to the government. But you need to be ready to talk, one, with integrity and honesty, but also with strength if you think you're right. And, we talked about how on a micro level, you shouldn't settle if you know you're right. But the reality is the board has to make a decision that's in the best interest of the company. And so many times, to avoid $2 million in legal fees for a slap in the wrist, books and records, $100,000 fine, you can completely understand the company doing it. But I think at the end of the day, the aspect is the board, the management, and outside counsel need to make sure they understand the facts. They know whether they are completely in the right or there's some gray area. And in those situations, I think companies, you need to hire counsel that can be strong with the government without being arrogant, ones that the government will respect, and you need to act that way with the government too. But if you're in the right, at least beginning with a position of strength and transparency is the way to go. But even with all of that, there are no simple answers. I'll give you one last little thing. Cobalt was so concerned about being right that not only did they hire a prominent law firm to do the due diligence, they hired 2 law firms. You would think that is fantastic. Well, one of the first lines when we took the case over that came from one of the government agencies was, instead of congratulating the company, they said, "Oh, well, if you hired 2 firms, that means you were worried." They took it as a negative instead of a positive. So you can do everything in the world, but still have these issues you have to go through, and that's the real world.
And, obviously the DOJ and the SEC have a lot of leverage, but your example, your client's example, shows that the companies have leverage too. It's called the law, it's called the facts, and it's called not rolling over in plain dead, because at the end of the day, the plaintiff, the DOJ and the SEC have that burden of proof. So thank you, Michael Goldberg, for sharing your perspective and your client's ordeal with listeners, because I think it's a very important message for many people to hear in this new era of FCPA enforcement.
Well, it's been my pleasure, and hopefully I won't have to have further conversations like this, because everybody will see the light and the system will work.
Thank you.